talk about, I guess, client retention. When you're getting a client, when a client calls you, they say they want to come in for a meeting, and they call you on the phone, they have a legal issue. I'm going to give a little brief example of how not to get that client. Any volunteers? They go on your feet. I'm going to get somebody in the back. Come for me. We'll do a little scenario. So, I'm the attorney, you're the potential client. You come into my office and give me a brief synopsis of something in charge.
Bank.
Okay. In charge of theft? Yeah. Okay. And were you by yourself?
No.
Okay. And what did you do?
What's that?
Did you do it?
Did I do it?
Yeah.
Depends what your definition of doing is.
You want to talk about plea deals?
If you'll help me.
Well, we charge $10,000. Stop right there. Name some of the things that I did wrong during this initial client contact.
Don't ask them if they're guilty.
Correct. That was one of the first things that I asked. Anybody else? What? Okay.
You typically save your price for sheet and after you've talked to them for a while.
Correct. Correct. What didn't I do?
Establish your lawyer-client relationship before you start talking about the details?
Correct. That's true. That's true. Something else that I didn't do was I gave her a price and I didn't even tell her how I was going to help her. You know, what is she paying for? What is she getting? What is my strategy? Thank you so much, I appreciate it. A lot of mistakes that newer attorneys or attorneys in general make is that they'll have someone come into their office and they'll sit and they'll listen to their story and then they'll just give them a price. No advice, no strategy, no hope for that client. So if a client doesn't know what they're paying for, why in the world would they hire you? Why would they pay you that money? Why does your how does your service justify that? So when a client is coming in, this is how you want to prepare for that client. When a client calls, you're going to want to find out exactly what they're charged with. You're going to want to find out when their next court date is. You want to find out if they already have an attorney, because sometimes that's the case as well. Set them up for a meeting, and they come in for the meeting, and what we do is we prepare potential client folders. And in that potential client folder, you want to pull their charges. So what are they charged with? Okay. If it's robbery, you want to pull the code section for robbery. You want to, any court documents that they may have. So if it's a federal case, there's a system called PACER. All you have to do is type in the person's name in PACER, and it'll show you the indictment if it's there. So you want to pull that indictment. If it's a state court case, then you just go on to court case information, which is public access, and you can download the charges as well. You want to pull the jury instructions, because the jury instructions are going to tell you what the prosecutor's burden is in this case. So you can talk to the client about that when you get there. And you're also going to think about possible defenses that you can speak to this client about. And I say possible because they may not be defenses that you can use in the end, but you don't want to start out thinking in a box. You want to think as broad as possible, at least in the initial phases. So when that client comes in, you're able to effectively talk about the charges, about the allegations, and about what you can do for them to assist them. What I usually do is I set aside at least an hour for initial client meetings. If it's a complex case with some of these larger white-collar crime cases that involve a lot of detail and documents, I'll set aside 2 hours at times. During that meeting, you're going to want your client to tell that story. Let them tell the story. Don't interrupt them. Don't make assumptions. Don't interject, just let them say everything and just get it all out. Because they've been wanting to do this, and they've been, you know, trying to just get this off their chest. And now is the time. So let them go ahead and talk. And they're going to talk about a lot of things that aren't even relevant. But during that first meeting is not the time to interrupt them. There's times where you may think something is not relevant during that initial meeting, and later down the road it turns out to be very relevant. So just let them get it all out. Don't make promises to your clients during the first meeting. Don't say, I know we can do this. I guarantee that. Tell them that you're going to do everything possible that you can do to assist them with this matter. What that does is it makes them feel confident, and it establishes a trust that this person is going to work hard for me. They can't promise me anything. They can't guarantee me that I'm going to be found not guilty. They can't guarantee me that my case is going to be dismissed. But if there's a way, I trust and have confidence that this person is going to find that way to do it. Now, when you're wrapping up your meeting with that initial meeting with your client, you want to explain the process, because they have no idea if they have ever been through the system before or what's going to happen. They don't know what an arraignment is. They don't know that a trial, you know, what happens at a trial. They don't know what happens at a preliminary hearing. So you want to explain some of those things to them. And once again, you're establishing your voice as the voice of authority, the voice of knowledge and information. You don't want them Googling things on the internet or speaking to relatives and other people trying to find this information out. You want to be the source for that information. And once again, explaining the charges and possible defenses to them. So moving forward past that point, in terms of the client and attorney relationship, when you get discovery in the case, share the discovery and the evidence with your client. Clients are a useful tool in dissecting this discovery documents, whether it's emails, witness statements. Have them make notes on that, because it does two things. One, it helps you out with your defense, and two, it makes them a part of the team. And clients want to feel as though they are a part of the defense team, and it allows them to do that. So be open with them about the discovery, and have them take the notes, and then set up meetings where you all can sit down and discuss the discovery as well. Stay in constant communication with your clients is very important. Some clients are more needy than others. I tend to find that clients with higher education levels, with master's degrees and very successful jobs, are very demanding. They're used to being in charge. They're used to driving the bus, so they'll call and want to be more active with the case. And you have to let them know that when it comes to this criminal matter and your representation of them, they can be involved, but you're driving the bus. You'll keep them informed, and they need to just trust them. Other clients, they won't call you at all, but you still need to reach out to them, and you need to communicate with them, even if it's just calling in, checking in, saying, you know, I haven't heard from you 2 or 3 weeks, just making sure everything's okay. If you have any questions, please feel free to call me. If there's any updates, you provide them with those updates. Something that you never, ever, ever do during that initial client meeting is talk about pleas. That is a very quick way to lose the trust of your client. Clients don't want to talk about plea agreements during your first meeting, because it sounds like you don't want to do any work and you're just interested in pleading them out. I can't even count how many clients that I've obtained from other attorneys, because when that client went into that first meeting, the attorney started talking about plea negotiations. I don't even like to even consider plea negotiations until I've seen this, because it's not necessarily what the client did, it's what they can prove. And you don't know what they can prove until you've seen the discovery. So, initial case prep. When I was a prosecutor in Philadelphia, the volume was just outrageous. And you know, we were new attorneys, and we would be in a preliminary hearing room, and we would have 40 a caseload of 40 prelims in one day. So the way that we began to prep our cases is that we would create a sheet, and at the top of the sheet was always the who, what, when, where, and how. So you want to know the players, whether it be the police officers, any witnesses. You need to know where it happened and when it happened. Those are your key parameters of framework. Once you know that, you begin to look into those individuals, whether it be the witnesses, whether it be a certain location, whether it be a certain period of time that happened in terms of visibility, may be an issue during some of the cases. So the way that you prepare a federal case is a little bit different than the way that you prepare a state case. The federal system, at least in the Eastern District of Virginia, which they call the Rocket document, you get discovery fairly quickly. At the arraignments, usually you're getting handed over disks or hard drives that you go through. And that's the initial aspect of really what you're going to be doing in the federal case. It's just really swimming through, especially in white collar cases, you should be swimming through tons and tons of discovery. I have a case right now that I'm working, and I'm not even halfway through, and we're already on page 490,000. And that's what they do. They overwhelm you with a tremendous amount of discovery, and you just have to get through it. Utilize PACER in the federal system, because there will be people that could be named in the indictment, in the body of the indictment, but when you look at the case caption, they're not a co-defendant of your client. So that means that either that person had been charged before and snitched on your client, so he has a case out there. So you want to find out what that person pled to and what was in their statement of facts. There's also a tactic in the federal system called a reverse proffer. Has anybody heard that term before? Okay. So a reverse proffer is usually done early in the process where the U.S. Attorney's Office and the federal agents will invite defense counsel and your client in to meet with them. And during that meeting, basically they will tell you why they think your client should plead guilty. They'll present you with evidence that they want to overwhelm you with, incriminating evidence that they believe will overwhelm you into pleading your client guilty. If this is offered, always take advantage of it. It gives you basically insight into their theory and their theme. I used to take my clients to these sessions, and then I stopped. Because when they go to these sessions, it's very hard for them to contain themselves. No matter how many times you tell your client, don't say anything, just listen. They'll blurt things out, and they'll say things, and once again, some of the clients with the higher levels of education are the worst. I was representing a doctor one time, and I reiterated, don't say anything, just listen. We get in there, and he just, they're presenting the evidence, and he just starts blurting things out, and they're taking notes. And come trial, they use those statements against him. So at this point, I no longer bring clients to those meetings with me. I just take notes and I report back to them what was said during the meeting. Also, at the same time, as attorneys, we need to contain ourselves in these reverse proffers, because some of the things that they're saying, we've already reviewed some of the discovery. We know it's not accurate, but we don't want to say anything. Just listen. Just listen and take notes. Because as soon as you speak up and correct their inaccuracies, you're just gonna go fix it. So just listen and use what you hear to your advantage. There's also what we call a regular proffer. So a regular proffer is when the government, the federal government, will invite your client in to speak to them. They say, well, we'll grant your client, they call it, it's called a Queen for a Day letter, where the client can come in and they can give their side of the story, and the statements that they say can't be used against them. But there's a cap. Statements made in that meeting can't be used against them unless they were to take the stand and say something different. So what it does is it boxes your client in to whatever they tell the agents and the U.S. attorneys in that proffer session. I don't bring my clients into proffer sessions unless there's already a plea agreement that's been signed. I don't think there's an advantage to it. I've never had a client go into a proffer session and afterwards, the U.S. Attorney's Office is saying, "Oh, okay, now we get it. We'll drop the charges," or even reduce the plea. It just doesn't happen. So basically, they're using it as a tool to really, I think they use it more so on younger attorneys to get defendants into their room and basically find out, are you in the case? So I don't ever really take part in proffers anymore unless there's been a plea intervention. In federal court, motions have to be filed quickly. In some courtrooms, some judges require them 10 days after the arraignment. So you have to get to that discovery quickly. And I say that, and you all should keep in mind, if you ever do any federal practice, please charge appropriately, is what I'll say, because it's demanding, it takes a lot of your time, and it takes you away from being able to take other cases. Because if you get a terabyte worth of data, which is, can be over 500,000 pages of this country, and you have to file the motions within 10 days, I mean, you can only imagine the work that you have to put in order to be prepared to file a motion. And there's multiple defendants in the case. You want to talk to co-counsel about adopting each other's motions. So you can basically split the motions if they apply it across the board. So, I can do 2 motions, other counsel can do other 2 motions, and then we do a general adoption of all the motions, which courts routinely grant. State court is a little different. So when you're practicing in state court, you're not going to get that much discovery. It can be very frustrating to a client because the client knows what they see on TV, and a lot of these shows are not accurate. And they think that you're going to get all of the police documents, you're going to get the witness statements, all from the start, and you don't. You don't. If it's a misdemeanor matter, you're going to get it the day of court. It's just going to be basically a prosecutor telling you what the officer would testify to. So the way that you can get around that is use your subpoena power. You can subpoena 911 calls. They don't always give them to you, but sometimes they slip up and they do. We've gotten several 911 calls. You can subpoena surveillance videos from either banks or Macy's or store locations. You can subpoena witnesses. Now, when you subpoena witnesses, you don't know if that witness can help you or hurt you, but they're going to do one thing once they get that subpoena. They're going to call you, and they're going to say, "Why am I under subpoena?" And at that point, you can use them to question them to find out what they're going to say. Another way of getting information is going to the court's file. The prosecutor's office is in a bad habit of when they're requesting subpoenas. they're putting the witnesses and even, you know, the victim's name, address, and phone number on the subpoena request form. All of that information is in the court's file. So when you go look at the court's file, you can get that information and you can call up the complaining witness. You can call up any witnesses. You can even call up the officers because you have all of their information. Now, I'm not saying that this information should be shared with your client. I wouldn't advise that. But as an attorney, you can call the complaining witness. A lot of times we get stuck at looking at alleged victims of crimes as, well, that's the Commonwealth's witness. We can't touch them. We can't contact them. Yes, you can. That's just a witness in general. You can call them. You can contact them. You introduce yourself. If they don't want to talk to you, they don't want to talk to you. But a lot of times, they'll talk to you for a little bit and just tell you about their version of what happened. And that's how you get ahead of the process, even though you're not getting a lot of discovery initially in the state court. When you have a felony preliminary hearing in state court, file a discovery motion. Usually prosecutors are going to wait until, once again, the day of to give you information about the felony case. But you can file a discovery motion beforehand and basically put in the order, the discovery order, that you'll get it 2 weeks in advance. So, I mean, and that's a huge difference because it's still not getting it the day of. The way that Fairfax and a lot of jurisdictions operate is that you get there on the day of court and they tell you discovery, they tell you the discovery orally, and then you go tell your client, and then there's a continuance. So it's just a waste of a hearing. It's just another day in court that if you had the information in advance, you would have been able to prepare. So try to do discovery orders and try to get it, you know, at least a week, maybe 2 weeks in advance. Plea negotiations. You always want to communicate plea negotiations to your client. No matter how bad they are, no matter how terrible they are, once you get a plea offer, you're required to tell your client. It's important that you tell them not only in person, but in writing. One of the downsides to being a criminal defense attorney is that at times you're dealing with people that just aren't, sometimes they're just not honest. And if they're convicted, they're looking for somebody to blame. And one of the ways out of that is to blame your defense counsel. And at times they'll just straight out lie on you. And they'll say that you didn't communicate plea offers, or you didn't tell them certain things. So when you get a plea offer, you want to communicate it to them either in a letter or an email. So if they ever say that you didn't tell them, you can go back and you'll have a record of that as well. So communicate the plea agreements to your clients. If you're in federal court and you get a plea agreement, you're going to want to review it and calculate the guidelines out and to see what the guidelines would be under that plea agreement. But more importantly, in federal court, we get what you call the statement of facts typed out with the plea agreement. You have to be very, very careful when you get a statement of facts from a U.S. attorney, because what they do is they insert little things that may seem insignificant at the time, but if you know your guidelines, you know that that one sentence can trigger an enhancement that could lead to an additional 2 years in jail for your client if they sign that statement of facts. So when you go through the statement of facts, you want to go through a fine-tooth comb and try to make revisions so your client isn't signing and agreeing to something that's going to enhance their sentence. And in terms of state court plea agreements, you want to do the same thing. You want to calculate the guidelines under that plea agreement. If the offer that you're getting in state court, or really in federal court for that matter, if it's the same that you would get if you had gone to trial, go to trial. You know, I mean, the decision is up to your client, but I would advise them to take a plea agreement or a plea that they would get the same result if they had gone to trial. And really, what that does is it establishes respect for you. For one, from your client, and two, from opposing counsel. Because Opposing counsel, once they know that you're ready and willing to go to trial, your offers will get better. If they know that you're just going to roll over and take any plea they throw your way, you're going to continue to get bad plea offers. Okay, so preparing for trial. The devil is in the details. When I prepare for trial, I want to know that case better than anyone else involved. And really, that comes down to repetition, going over the police reports and the documents over and over and over again. So when your witness is on the stand, or a witness is on the stand, and they say something that's not right and inconsistent, you're able to pick it up right away and cross-examine them. If you have exhibits, don't go to court or be in front of a jury or a trial like this, fumbling with exhibits and trying to find them. Be organized. Have an exhibit binder. If you don't have that many exhibits, then at least put it in a folder and invest in some exhibit stickers rather than just using your pen and marking it 1, 2, 3. They're not that expensive. And it goes a long way in terms of professionalism and just the way that you're presenting yourself. So just have everything organized. If you are able to utilize technology, use PowerPoint, or there's a program called Trial Director because it helps retain attention. Jurors like to see visual things. It helps with the presentation. So think of using PowerPoint or Trial Director during a trial. When you're preparing your witnesses for a trial, think about, how does this witness help me? What can I get from this witness? And how does this witness hurt me? When you're preparing your cross-examination, think about the inconsistent statements. Be prepared and organized to confront your witnesses on the inconsistent statements. So if you know if a person has given an inconsistent statement in a grand jury testimony and also gave another statement to police officers, have those documents queued up and highlighted exactly where the inconsistencies will be. So when you confront them on the stand, you're not going to lose that point fumbling trying to find the actual inconsistency. Have it already queued up so you can point right to it and make your point and move on. If your client in a criminal defense case decides to testify, 3 words: prep, prep, prep. If they made any prior statements to anyone, you want to have them review that statement ad nauseum. They need to go over it again and again and again. Because if they've given a statement, whether it be to detectives, it's recorded, or an officer, they're boxed in by that statement. If they say anything different than that statement, it looks like they're minimizing, it looks like they're lying and just inconsistent. So they need to be consistent and have the same overall statement. You want to talk to them about their demeanor. If your client has a lot of hand gestures, if he or she likes to do things like that, those aren't good in a criminal defense case. So they need to, whether they need to clasp their hands or whatever, appearance is very important. Because at least in criminal trials, I know, the juror is always looking at you, whether they realize it or not. When they come out, they stand up and leave. It's almost like theater. They're looking to see what this person is doing. They're hearing testimony, and they're looking at that person and say, "Could you really do this? Could she really do something like that?" And they just glance over and look. I don't like my clients reaching over and whispering in my ear during trials. I give them a pen and a legal pad, and I say, if you have questions or you want to raise something to me, bring something to my attention, write it down. And, I don't want to see you doing this the entire trial because it shows desperation, nervousness. Just be calm, write down your suggestion or statement, and slide it over to me. All of those things play a factor. They may seem small, but they're very serious. Openings, I hate doing opening statements. If I could waive them at times, I would. But you establish your case theme. You want to use keywords. Don't be too specific. Don't box yourself in with your opening statement. Don't make promises to the jury that may not happen. Don't say, you're going to hear from my client because he may not testify. So try to be as broad as possible. And then when you get to your closing, and also during your opening, introduce your client. I have my client stand up. I introduce them by name, and I have them, take a seat. And then I tell them a little bit about my client. What do they do for a living? Do they have children? Where are they from? Because the prosecution doesn't hear about that, and they don't want the jury to know about that stuff. They want the jury to just look at this person as an object, as a defendant who doesn't have a life, doesn't have children, doesn't have a wife, doesn't have a career. And our clients have all of that stuff. So you want to bring that up during opening statements. During closing, pretty much it's the argument phase. You're bringing home all your themes. You're highlighting the weaknesses from the government, and you're highlighting their strengths. Go back to that theme that you established in the beginning and hit those points. You have to let me know how many time.
It's 2:21. You have till up to 3, if you like.
All right. So sentencing, federal versus state. In federal court, when you're at the sentencing phase, it's pretty much a requirement that you file a sentencing memorandum. And they're due a week before the sentencing. Now, it's important to get these memorandums in and to not just gloss over them, because this is your chance to convince the judge as to why your client should receive the sentence that you're seeking. We want to talk about not just the guidelines, because the guidelines are just one factor. And they're advisory, they're not mandatory. We want to bring up the client's background, talk about his family. How was his upbringing? Talk about activities that he did in high school, she did in college, community service, church. Get individuals to write letters for the client. And try to use a cross-section. Try to get a letter from coworkers, letters from family, letters from neighbors, kind of a cross-section of society, so the judge can have a good idea of how your client interacts with people from various different aspects of society. If there's diplomas, awards from work, or military service, make copies of those and include those in the sentencing memorandum. Use pictures of your client's family. You can actually insert those into the body of the sentencing memorandum. If your client has children, put pictures of the children into the sentencing memorandum. Talk about the client's decision to take part in criminal activity. What was going on in their life that caused them to end up in this position? I've had several cases where individuals can live their life as upstanding citizens 99.5% of the time, and then make a fateful mistake over one day or several weeks that can put them in bad decisions. So you want to talk about that rare occasion that caused them to take part in criminal activity and contrast that against the rest of their life and how they lived their life. Clients are also given an opportunity to make statements. I can't stress enough that you are going to want to have your client's statement to the court at sentencing pre-written. If your client is telling you that they are going to get up and just speak from the top of their head, you say no, because it's never a good thing. And it's not that necessarily that these clients aren't intelligent. It's that they're nervous, they're scared, they're emotional. So it's better for them to pre-write a statement out that you can assist them with. So either they can present it beforehand, which I recommend, or they can read it to the judge during the sentencing phase. So state court is a little different. If you go to trial in state court and your client is found guilty, then you immediately go into the sentencing phase if it's a jury trial. You need to prepare for that just really at the same time as you're preparing for trial. Because if your client is found guilty, then you need to call sentencing witnesses. So have family members there, co-workers, anyone that could testify to your client's good character traits to the jury, and bring out that same information that you would bring out in the sentencing memorandum, good quality traits, and how your client is been a good citizen. So now let's talk about dealing with prosecutors. I was a former prosecutor in Philadelphia, and I was a prosecutor there for several years. I can tell you that the training process that we initially go through was like brainwashing. And it puts you in a place where, at least as an initial prosecutor, as I look back on it, I was unreasonable. There were times where I could have definitely exercised justice, and I did not. In terms of, yeah, this person may have committed this crime, but there were other solutions that could have been worked out, plea negotiations. But I was a young attorney, and I thought that everybody should be prosecuted to the fullest extent of the law. And I didn't know. There's a lot of senior experienced attorneys like that in this area. And sometimes it can be difficult to deal with. So you want to get to know the individuals and prosecutors that you may be dealing with in a certain case. Know their personalities, from either other defense attorneys or just your own experiences with them. One thing that I say is that there's a lot of defense attorneys who feel as though they have to be liked by a prosecutor to get a good deal. You have to try to be friends with them. I don't really subscribe to that theory. I think that it's better to be respected than liked. I can tell you right now that a lot of Fairfax County prosecutors do not like me, but they respect me. And that respect has gotten me several good dispositions for my clients. They know that if they give me a terrible offer, that I'm not only going to take the trial, but I'm going to motion them to death. I'm going to file every single possible motion that I can. And I'm going to make everything miserable for them. So having that respect and them knowing that you're a thorough attorney goes so much further than the collegial, you know, hey, how you doing? You see the game last night? Oh, by the way, can you offer this for my client? Because they have no reason to be your client. They're motivated by, and I don't want to be too, they don't have personal stakes in these cases like we do. So a lot of times they want to get things achieved with as little work as possible. And if you're going to make them work hard, they're going to try to avoid that. So if they can give you a better deal to avoid having to be in court until 5 p.m. on a trial, they're going to give it to you. way that I approach plea negotiations with Commonwealth Attorney's offices is that I don't go in and I don't ask for things. I don't ask and say, can we do a reckless instead of a DUI? Can you amend this down from grand larceny to petty larceny? A little bit more assertive when you go in to that room and speak to them. When you sit down and you have certain factors, and you sit down and you say, this is what I'm trying to do. This is what I want to achieve here. And this is why we should achieve it in this case. And whether it be your client's background, whether it be some type of mitigating factor about the case, you want to bring up those things in order to get them to agree with you. And it just kind of carries a tone when you're basically telling them what you want to accomplish rather than asking them, can we do this? Or can you please offer me that? Because they're usually going to say no. Something else that you don't want to do when you're negotiating with prosecutors is do not reveal the weaknesses in their case. A lot of attorneys think that if you go in there and you tell them how weak their case is and how you have these defenses, that they're going to change their mind and they're going to give you a better offer or they're going to drop the charges. They're not. All they're going to do is go in and basically correct their weaknesses. They're going to bring their officers in and prepare them for every weakness that you just pointed out. I've seen it done time and time again. So you go in there and negotiate with them based upon different factors, but do not negotiate with them based upon the weakness of the case. And once again, if they're giving you an offer that is the same as you would get a trial, go to trial. Especially if you're a younger attorney and you're trying to get experience and your client is okay with it, then get that trial experience. Go to trial. And then once again, word will get around that you're not willing to take bad offers. You're going to take it to trial and you'll get better offers. Okay, so dealing with judges.
I have a question.
Yes.
So you said don't reveal to the other side the weaknesses of their case when you're negotiating. So what factors do you bring up at that point?
Bring up things about, so what you want to do is you want to know as much about your client as possible in terms of, this person has no prior convictions. They're in college right now seeking their degree. They have done X, Y, Z since this has happened. They've paid restitution. So you want to bring up factors like that in order to try to resolve it. I've spoken to the complaining witness. They're okay with this type of disposition. Those type of factors to negotiate.
Okay.
So when you're dealing with judges, and I guess this can go across criminal, civil, or whatever. Judges are people. Don't always be so quick to be agreeable with them. I've seen it where an individual is communicating a strong point of law to a judge, and they're correct, and the judge will pronounce, something that's incorrect, and the person will just back down and say, okay. Don't be so quick to defer to them. Be respectful, but if you know that you're right and you have the case law is on your side, the rule of evidence is on your side, stand firm, and don't be afraid of a little bit of back and forth with the judge, because for one, you're going to gain respect from your client, and chances are you're probably going to gain respect from the judge as well. In terms of judges' demeanors towards you, don't let them disrespect you either. When I was a new prosecutor in Philadelphia, and it's the prosecutor's office there is over 300 attorneys. Every year they hire 30 prosecutors to come in. The judges knew when the new attorneys were starting, and we would be in court, and we didn't know that much. We weren't that experienced. But at the same time, some of them were very, very disrespectful to us, and they treated us bad. And I guess it was kind of like a hazing process. But you don't have to take that. Although you may be a new attorney, you've gone through 7 years of schooling, you've earned your stripes in terms of your education, and you don't deserve to be disrespected by opposing counsel or a judge. So if you're clearly being disrespected by a judge, then point it out to them and let them know that you recognize that they're treating you unfairly or inappropriately. Because a judge, just like, if a judge is a bully, just like a schoolyard bully, if they know that they can do that to you, they're going to do it to you over and over and over again. But if they make a remark to you that's disrespectful or unkind, and you respond and let them know that you recognize that, they're probably not going to do it again, because they don't like their authority being challenged. And when you challenge them in a room full of people, they get embarrassed. So they're going to be less likely to try to push your buttons or push you around in the future. You know, I know a lot of people may not be comfortable with that, but you know, it's kind of the profession that we've chosen, and it can be very adversarial sometimes. And just like with opposing counsel, sometimes it can happen with judges. Like I said, always be respectful, but you don't have to let them, and don't allow them to disrespect you. A recent example that I have of that is a certain judge in Fairfax County, and it was during a bond motion, a very contentious bond motion. It was appealed at this point. My client had been charged with 2 counts of object sexual penetration, and the Commonwealth had won the bond argument down below. My client was denied bond, so we appealed it. And we took it upstairs, we went upstairs, and during the bond hearing, I began to talk about the allegations. And the judge just cut me off quickly. He said, "We're not here to talk about the allegations. That's not my job. That's not one of the factors." And so I said, "Judge, you're telling me that, but the prosecutor plans to get up here and base the majority of their argument about bond on the allegations." And he just dismissed me. He said, no, they won't. So shortly thereafter, I finished my bond statement, and I sit down. The attorney stands up, and sure enough, they start talking about the allegations, and the judge does not stop. So at that point, it's an immediate recognition by me, and also my client, who's looking at me, and his family and friends that are in the gallery, that he is for some reason treating me differently than he's treating the prosecutor and giving him an advantage. So I stood up, and once again, being respectful, I said, "Your Honor, this is exactly what I was talking about. And why is it now that you're allowing him to do exactly what you refused me to do?" And he kind of just sat back in his chair, and he looked at me. And that's what I mean in terms of the feeling that they get when their authority is challenged in public. It's that uneasy feeling. And he said, "Counsel, I understand your position, and I'm going to let you respond." Now, if I had just sat there and not said anything, he would have gone through that day, whether he would have done it again to me or to someone else. But it's important to challenge them when they're not doing things or not treating you fairly. Okay, I think that's all I have. I want to open the floor up to any questions you all may have about me or my experiences.
I was wondering what your approach to jury selection is and how long you spend researching jurors, what kind of considerations you make.
Okay, yeah, so most of my trials happen in federal court. In federal court, the judges pretty much do the voir dire. We're just kind of passive observers of the whole process. But we do get the jury list fairly early. We get it the weekend before. So we've Facebooked individuals individuals to see what's on their Facebook pages. When I go through the selection of a juror, you know, to me, the two most important things are, what does a person do? What do they do for a living? Because, you know, jury selection is really all about assumptions that we're making about them. So when I'm looking at a person's profession, I want to know how they think. So if they're a psychologist, if they're an engineer, I like individuals like that because depending on, so if it's a white collar crime case, I like people to think. People who ask a lot of questions, like why, how, or if there's a piece missing, then they just can't make that conclusion. With the same type of cases, I try to stay away from people who are either government employees or blue-collar workers. And there's nothing wrong with being a blue-collar worker. My family comes from, you know, a blue-collar background. But in my experience, those jurors tend to see the government as the voice of authority. It's kind of, well, this person is in charge, and this is what I'm going with, and I'm not going to really necessarily question what they're doing. So that's one thing. The second thing that I look at is age. I find that younger jurors are less judgmental than older jurors. So those are the two things that I consider more than anything else. In state court, we do the actual voir dire. You're asking the questions of the jurors, and basically it's your way of kind of getting your theme out there of the case. Telling them a little bit about what the case is about and making sure that there's nothing about this case that is going to cause them or that would cause them to be unfair towards your client. If it's a gun case, you know, maybe one of the potential jurors has, you know, had a relative that's been shot or been affected by firearms. If it's a drug case, maybe they have a child who's been addicted to narcotics, and your client is a drug dealer, so those things are mindful. The last, one of the last cases I had was taking decent liberties with a minor case, and I had to ask them an uncomfortable question of the jurors if any of them had experienced any type of sexual abuse in the past. And there were several jurors that were forthcoming about that, and I had to strike them from the jury. Some of them admitted that you could not be fair with this. Any questions?
Thank you.